If the police come and interrogate you about a crime in which they think you're involved and you confess to that crime, don't panic. It's not over yet. You may think you've just convicted yourself. Not so fast. In this video, I'll explain how your confession alone is not nearly enough to convict you of a crime. Hello folks, I'm Andrew Williams. Welcome to another edition of the Fedora Lawyer. I'm board certified in criminal law and I have 30 years of experience trying criminal cases. On this channel, I share my years of experience with you to help you better understand the law and maybe use it to your benefit. On this channel, however, I provide general legal information about the law, but the law varies from one jurisdiction to another, one state to another, and obviously one country to another. Therefore, if you do have a legal problem, make sure you consult an experienced attorney in your area to advise you about the facts and the law concerning your case. So why isn't your confession enough to convict you of a crime? Well, because in most jurisdictions, the law requires other evidence to connect you to the crime. Just admitting to it is not going to be enough. So, if you slip up and happen to incriminate yourself during a police interrogation, you don't need to panic. And no doubt your admission can be used and most likely will be used against you if you ever decide to go to trial. But again, your word alone is not enough for a conviction. Courts generally require corroborating evidence to support your confession. Corroborating evidence is other evidence connecting you to the crime to which you just confessed. This could be your fingerprints at the crime scene, DNA found at the crime scene or on the victim. Maybe a witness saw you at or near the crime scene at the time of the crime. An instrument of the crime was found in your home during a search, like a gun with your fingerprints on it or a knife, something like that. One of the primary reasons why a confession alone cannot lead to a conviction is because of the well-documented occurrence of false confessions. A lot of people confess to crimes they didn't commit. People falsely confess to crimes for various reasons, including coercion by the police, psychological distress, lack of understanding of the law, low IQ, or a desire to protect someone else. And there are plenty of real-life cases where innocent people have been convicted based on false confessions, only to be exonerated years later by DNA evidence or faulty eyewitness testimony or something like that. That is why an admission by itself is not enough. Even when you voluntarily plead guilty to a crime in open court before a judge and you're under oath, the judge will not accept your plea of guilty until the prosecutor has provided the judge with additional supporting facts to support your plea. This is known as a factual basis for the crime. The prosecutor will read the factual basis to the judge in open court, and then the judge will turn around and ask you, is that true? Did you do what the prosecutor just said you did? If you don't agree with the factual basis, or the factual basis is not sufficient for the judge won't take the plea of guilty and you won't be convicted. And that's how it works. That's why your confession alone is not enough. I hope this information was helpful. If it was, hit the like button for me. If you like getting videos on legal topics like this, you can also subscribe to this channel. You can also visit my website at fedoralawyer.com for more information on other legal topics. For now, this is the Fedora Lawyer signing off.